Oh, okay, I think we are live. Welcome, everyone. Thank you so much for joining. My name is Rodrigo Palhas. I'm the Vice President in charge of seminars and conferences of Health International for this term. I'm very honored to start this webinar organized jointly by ELSA and by Aeroprivacy. Aeroprivacy is one of ELSA's partners, and we are very grateful for their support in this webinar. As you can see, it will be on data protection during these 3 days. We will focus on different topics. And yes, I will be very short and simple. Just thank you, everyone, to being here and engaging in ELSA's events, and to Aeroprivacy, of course, for their unconditional support to organize this webinar. I will give you the floor now, Dr. Schiegler, for the presentation.
Thank you very much. And first of all, I would like to thank ELSA. It's a great pleasure to collaborate with ELSA. It's we have a long lasting collaborations in several years. We are so welcoming regularly interns from ELSA in our program. And I have to say that part of the development of Aeroprivacy is also the results of several ELSA interns who have contributed to different developments. So it's a great pleasure to share with you the achievement, the results, and the evolution of this major topic, which is GDPR certification. And for these, I have the great pleasure to have with me two outstanding experts. On one hand, Luca Bolognini, who is not only the president of the Italian Institute for Privacy, so the founder of the largest major law firm in Italy in the field of digital rights, but he's also one of the parents of Aeroprivacy, because the scheme was in part developed in a project we were leading together in the European Research Program. So Luca has a quite unique perspective on it from different angles, as an insider of the scheme, but also as major reference in Italy and internationally in the field of data protection compliance. And we have also the great pleasure and great honor to have with us Giovanni Francescuti, who is one of the director of DNV. And DNV, for those who are not aware, is one of the world leaders in certification. You have, I would say, a few top 5 global certification bodies who are really global presence, and the DNV is one of them. And it's a great honor to have DNV as one of the official partners, and they are one of the front runners of GDPR certifications. It's a great pleasure to have them both with us. Let me now maybe just ensure I can share my screen. Can you see my screen?
We can see, Sebastian.
Wonderful. So let me put it in full screen. So the agenda, very briefly, we have an introduction of the GDPR, and then the idea is really to discuss some legal and governance aspects, certification as a compliance and accountability tool, and some practical and implementation and technical perspectives. So really giving you a kind of comprehensive view of what it is, what is the purpose, how does it work, how do you implement it in practice, and to have some time for some Q&A. Let me move to the next one. So first of all, GDPR certification. It seems to be simple, but it's a quite new and very innovative approach, because usually you have legal obligations on one hand, and you have certification on the other side, which is usually based on a voluntary basis, usually in 99% of the cases, and which is often disconnected from the regulation itself. Even if you can have certification which are assessing compliance with certain regulatory principles, but usually these are more or less two worlds which are parallel. The world of law and legal obligation, the world of certification. What is very interesting with the GDPR is that it brought together these two worlds to work hand in hand together. And the GDPR certification aims at enhancing transparency, enabling companies, but also data subject to quickly assess if a service or data processing is compliant with the regulation. It's about legal compliance, meaning there is no compromise. Not about, oh, is it more or less compliant? No, is it complying with the GDPR or not? It's about evolving requirements because the regulation, the law, due to jurisprudences, due to evolution of the legal framework, is a moving target. I mean, the interpretation, for instance, of pseudonymization, of pseudonymized data 1 year ago and today has changed. So we have quite a number of elements which are moving, meaning that compared to traditional certification, we need to align and adapt to the legal evolution in the context of GDPR certification. And then it's, of course, certification which impacts a large diversity of data processing. If we look at the GDPR, we have 4 mechanisms, 4 instruments, which are made available to SMEs or companies or public administrations to demonstrate the compliance. You have 4 mechanisms, and among these 4 mechanisms, it's interesting to notice that the GDPR certification is the most referred mechanism. We have 73 references to certification, which is more than all the other references in the GDPR to SCC, so standard contractual clauses, BCRs, and codes of conduct. And if you look at the specific references, for instance, the GDPR certification is the only mechanism recognized by the GDPR to demonstrate compliance with privacy or data protection by design and by default under Article 25. And that's very interesting because that's often an article where many companies struggle to understand, to say how they can demonstrate the compliance with this obligation. And certification is a mechanism recognized by the GDPR to demonstrate this compliance. But the same way you can use certification, GDPR certification, to demonstrate the adequacy of data controllers under Article 24, the adequacy of data processors under Article 28 of the GDPR, the adequacy of the security measures in place under Article 32. It is also a mechanism which is recognized as having legal effect on the calculation of the administrative fines, meaning that if you are certified, the judge must take into account that you have been proactive in preserving and protecting the rights and freedoms of the data subject, which is very interesting. Then, of course, it's an instrument which has other characteristics, inherent characteristics. It's applicable to any industry. There is no restrictions, while a code of conduct is usually something which is sectorial, very limited to a specific sector. It is valuable as an intangible asset, and we will come back to this. That's a major element that a certification can be valued by the company, by the DPOs, to demonstrate, to turn the compliance into a resource that can be valued in terms of recognition, but also economically speaking. It is also, it also enables the possibility to focus on priority areas. So just, okay, maybe for me as a DPO of a company, I consider the highest risk is maybe with the customer support service, then I can focus my effort on the customer support service. And then it is highly scalable. And the reason why the certification is so largely referred into the GDPR, again, 73 references, is due to the fact that if you compare the level of trust in the different mechanisms, I just compared to the standard contractual clauses, you have a formal commitment, but with such right of access and control. You don't know what is effectively implemented, but you have a commitment to respect the GDPR, while the certification relies on regular audit, systematic audit by third parties, professional auditors will come and ensure that what has been committed is effectively implemented, that the reality is aligned with the commitment. And that's a fundamental difference, which explains why a certification has far more value and is far more trustable than other mechanisms in the context of the GDPR. So let's speak about EuroPrivacy. Let's introduce EuroPrivacy. EuroPrivacy was developed through the European Research Program. We started working on EuroPrivacy 13 years ago, before the GDPR, trying to see how we could translate the obligation of the former directive, European directive on data protection, personal data protection, into auditable criteria, into a methodology to assess the compliance with the original directive. And when the GDPR was approved, we decided to work with research colleagues like Luca and others to work together to formalize a formal certification scheme for the GDPR. The scheme, the criteria were approved under Article 42 by the European Data Protection Seal in 2022. And then they were approved by EDPB, so by EDPB and by European accreditation a year ago, a little bit more than a year ago. And that enabled us so to have a common accreditation mechanism for all European authorities. The initial criteria, which have been approved, which are currently in use, were approved to be used in Europe, but currently there are ongoing work with EDPB to open Europe to certification outside of Europe, either as direct certification, regular certification under Article 42, or as a certification to be used as a mechanism for international data transfer under Article 46. And we expect the opinion, hopefully, but around April, in principle, we should have the official opinion for EDPB. So what does an applicant need to be certified? Fundamentally, it is a certification which will assess the compliance with the regulation, with the GDPR. So what an applicant needs is to be compliant with the GDPR. So to do his homework that he has to do anyway, regardless of any certification, to comply with the different GDPR obligations. Then to have a DPO and a record of data processing activities. As you know, under GDPR, it's not mandatory for all companies. Small SMEs do not necessarily need to have a DPO. But for the certification, you need to have a DPO and a record of data processing activities. In other words, you need to have someone who is in charge of the compliance, and you need to ensure that the company knows what personal data it is processing. And then what you need fundamentally is to document the compliance. The good news also with GDPR certification that you can really focus on data processing or activities which look for you more important. It can be data processing related to products, to services. It can be customer support services, your website, your online services or SaaS platform and so on. But you have this possibility to focus. And then you focus on the priority data processing, and then progressively you can extend it to other activities. How does it work? You start, as I mentioned before, to comply with the regulation, not with the criteria initially, but with the regulation. And that's something you have to do anyway. Then you check and document your compliance with the criteria of the certification scheme. That enables you to reduce the risk, to check and validate that indeed you are effectively complying with the regulation. Then you certify. When you certify the compliance, then you turn your compliance into an asset, something you can value, something that can be used by the marketing team, that can be used by in your relationship with the investors, if you're a large company. So the financial analysts, you can use so to get an edge on the market, a competitive advantage when you try to get new customers, new clients. And then finally, once you're certified, you maintain and you take advantage of the certification. So you really enjoy having a new instrument and new resources to value your compliance, to engage, to develop new relationship with other stakeholders. And if you look at the evolution of the process, what is very interesting that most of the effort for the GDPR compliance is done before starting the journey of certification. I mean, 80–90% of the effort is done before you start even the certification. So what you do with the certification is already when you document your compliance is to reduce the risks. It's okay, we've done a lot of effort, we invested resources to comply with the GDPR, but now we want to be sure that we have done it right. You need then to have a mechanism, an instrument to assess your level of compliance. That's why you can use the criteria of Euro privacy to assess the level of compliance, to systematically control that you are all right, you are really on the safe side of the street. It's like a pilot in a plane before taking off. He will check that everything is fine, that the engine is ready, that there is enough kerosene and so on. You can use the criteria the same way, just to control your level of compliance. And then once you decide to certify, the beauty of it, that you really have this paradigm shift. You transform compliance, which is usually perceived as a cost, as a source of value creation. You really start valuing the compliance. So enabling the DPOs, the compliance office team, and the companies to value the effort they have invested in complying with the GDPR, and then you continue enjoying it. So there's a kind of virtuous path from complying with the law to valuing the compliance with the law through the certification. What are the main motivators? So I would say the first one is to check and prove compliance. I mean, a certification, if I tell you, oh, I'm complying with the GDPR, you can say, oh, Sebastian says he's complying with the GDPR or his organization is complying with the GDPR. That's his voice. It's nice, but is he really reliable? Is he impartial in his statement? No, I can be biased. I can be indulgent, complacent with myself. Then the certification is a way to have a formal check and validation of the campaign. Then it enables to reduce the risk, legal, financial, and reputational risk. It enables also to simplify compliance because then you are using practical criteria which have been approved by 30 national authorities plus the European Commission to be adequate for assessing compliance with the respective obligations of the GDPR. Then it enables to build trust, to develop competitive advantages, to value compliance, we mentioned it, that's very important, to facilitate data sharing, so with processors, with other countries, so to really facilitate the transfer of data, to save costs. In particular, if you have companies which are acting either as data controller or as data processor, under Article 28, the data controller is responsible and liable to ensure that the data processors are processing data with all due care. And then it implies to spend a lot of resources for due diligence on both sides. So to organize visits, inspections from company one to company two to ensure that the processor is really handling with care the data. Otherwise, the data controller is liable for anything that may happen with the data processor. Then the possibility to extend it to other regulations, and finally, to have a mechanism that is legally recognized by all EU and EEA countries. You can have a look at some of the initial testimonies of different pioneers in the certification, from Allianz to PricewaterhouseCoopers Luxembourg to startups like Angel, startup in the AI. And that can be an interesting perspective also to see what are the takeaway and what were the benefits and the motivation to be certified. It's usually turning around the previous points I just mentioned before. Now, in order to support the implementation of the certification, we developed several resources, including there is a public website, there's an online academy, and there is an online website with all the resources which are required to prepare the certification and to support the certification. And in the academy in particular, which can be interesting for you as student, and my dear colleague Giovanni Francescotti will tell you more about this in a few minutes. But for young professional in the field of law, there's a complete new areas of professional opportunities, new career which is emerging related to legal experts for audit and certification. But the online course is structured in different modules, and you can find more information online. But as ELSA member, you have privileged and reduced access to the academy, online academy. The academy is available already in several languages, English, French, and Italian, and we will soon have the Japanese, Spanish, and German versions published. Now, a few words about normative extensions. The Euro-privacy criteria are very much focused on the GDPR, but what about non-EU countries? If you would like to certify your compliance with the EU regulations, but perhaps also with the Japanese or Swiss Federal Data Protection Act, or the UK or Brazilian or other regulations. So what we developed together with Euro-privacy criteria is what we name criteria extensions. So we have about 15 countries for which we have specific complementary criteria, meaning that you can use the Euro-privacy criteria. And if you want, and you're active, for instance, in Japan and India or California, you can add a few additional criteria to cover the obligations of other regulations, other legal frameworks. We also have interprivacy. We have a dedicated webinar tomorrow on interprivacy, so I will not spend too much time on it. But just for you to know, there is the equivalent of Euro-privacy for Europe at the international level. It is named interprivacy, and tomorrow we'll give you more details about it. Then ECCP is working on quite a number of other regulatory compliance certification and assessment schemes. I will not dive into it, but you have schemes like, for instance, AIA Cert, which is assessing compliance of data processing products, services, and other scopes with the AIA regulation in Europe, but also OECD principles and the framework convention of the Council of Europe. And that's it for the introduction to your privacy. And now I suggest to give the floor to my distinguished co-panelists, and starting maybe with Luca. The floor is yours, and I'm sure you will have many interesting, insightful, and inspiring comments.
Thank you. Thank you, Sebastian. Thank you for having me here. Yes, you mentioned that I have several hats, so I know very well the Euro privacy scheme, but I'm also a business privacy and data lawyer, so I can understand the perspective of the implementers of such schemes, this kind of certification. Our firm acts as an implementer, a Euro privacy implementer, so we can accompany controllers and processors trying to prepare themselves to get certified. And this is very useful also to understand what kind of advantages a certification, a GDPR certification like this entails for companies, for undertakings, for organizations. I would say a thing that could appear obvious. You know, I suppose that you all know that the whole GDPR discipline, the whole data protection, personal data protection in Europe since 8 years, 10 years. This year we will celebrate the 10th year of GDPR, approved in 2016. But the whole discipline now is based on the principle of accountability. And the principle of accountability refers to general principles that have to be respected when processing personal data, principle of purpose limitation, data minimization, accuracy, and so on and so forth. And these principles, they seem to be clear, but they are not that clear. It's more or less a brain teaser to understand how to precisely apply all these principles to each processing activity, to a specific organization. And I would say that this is the main challenge for a lawyer, for a consultant, trying to assist and to help organizations to comply and to demonstrate compliance with the GDPR. The principle of accountability is another principle which is not substantial. I mean, principles of lawfulness, fairness, transparency, the purpose limitation I mentioned, data minimization, accuracy, storage limitation, integrity and confidentiality are substantial principles. Generic enough, but substantial principles. The accountability principle is different. It is a methodological principle. The accountability principle is that imposing that the controller shall be responsible for and be able to demonstrate compliance with the principles, the substantial principles I mentioned before. So we are talking about the Article 5 of the GDPR, to be clear. The accountability principle is particularly challenging because it is not about the substantial respect of principles and the substantial respect of the specific requirements that we find in the GDPR and also in the national laws as applicable, but it is about the demonstration of such substantial compliance. So a level higher, it is not enough to be substantially compliant, to respect substantially the principles, to meet the requirements set for by the GDPR, but you have also to demonstrate, to document and demonstrate such compliance. And that is the most challenging aspect of GDPR compliance. How an organization, an enterprise, a company could appropriately document and demonstrate compliance. What documents, what documentation, what materials, what evidences should be established and provided in case of controls, for instance. Of course, all the law firms during these years worked a lot on possible documentation, standards, models, organizational models, policies, procedures, a lot of paper. But it was always difficult to understand the degree of detail, degree of clearness of such documentation, also because the interlocutor checking, verifying the robustness of such documentation is the authority. Normally, is the authority during a procedure, or at least it could be another law firm carrying out a due diligence. And it is very difficult to anticipate the needs, to anticipate precisely what the authority checking and verifying will ask for, will want to find in those documents in order to recognize that the accountability principle was respected. And here, the certifications come as an accountability tool. You were right, Sebastian, mentioning from the very beginning of your presentation the fact that certification, according to Article 42 of the GDPR, the certification is an accountability tool. It is an accountability tool. I would say it is a language. It is a methodological tool establishing a standard, a common language, in order to communicate compliance. So, yes, indeed, you have to be compliant substantially. But certification, with all the checklists, the models, the documentation, which is standardized thanks to the scheme, can help building up this accountability framework, which otherwise would be very difficult to be agreed also in the dialogue with the authorities or with other experts. Certification is a way to translate substantial compliance in verifiable compliance, in accountable compliance. And so of course, it lowers the risks, the regulatory risks. It helps organizations in order to rationalize and better understand their positioning, their status in terms of GDPR compliance. It helps a lot, and this is strictly linked to the accountability principle. It helps a lot also in measuring compliance. And measuring compliance is always difficult. Talking with lawyers, we all know that our KPIs are difficult because uh, if you are not winning a lawsuit, but if you are assisting and accompanying a compliance work, often it is difficult to identify KPIs, to identify indicators, to explain the results and the successes that are that have been achieved, to explain such things to the board, for instance, or to other directors, or externally. Instead, obtaining a certification not only would help the order and the compliance in terms of accountability, but it would help, and it helps actually, the measurement and the communication of results to the board and to other stakeholders. This could be relevant also in terms of sustainability, because we all know that data protection, protecting rights like personal data protection and privacy means also protecting elements and valorizing elements that are relevant for sustainability, for corporate social responsibility, and so on and so forth. So I would say certification as a key for compliance, accountability, bringing more legal certainty to the company, to the controllers, to the processors, but also to the lawyers, advising their clients, bringing more evidences to the measurement of compliance, which can be valorized also in other fields, like sustainability, with other stakeholders that are not lawyers or the authorities, but are other stakeholders in other fields with other competencies, including the board of the organization. And in all this journey, I see also another effect. I could call it a side effect, but a positive side effect. I see that I mentioned at the very beginning, it's 10 years that we have the GDPR. I remember the first years of GDPR implementation, around 2016, between 2016 and 2018, of course, the year of complete application of the GDPR, but also immediately after. We could say between 2016 and 2020, there was a lot of work. All big organizations, in particular, were excited and focused on setting up the GDPR models, safeguards, procedures, policies, and so it was a period of great effort, but also great commitment inside the organizations. Then, after 2020, I perceived less, let's say, less enthusiasm internally in the organizations. The big work was done, and they felt compliant, even if in many cases it was not the reality, but they felt to have worked a lot, to have established good models, and so this was a mission accomplished. Today, during last years, it is becoming more and more important, I would say paramount, to find again such enthusiasm for data protection and data protection compliance. And the projects we are following in order to help implementing compliance with the objective, with the goal of certification, are projects that are bringing new enthusiasm, new momentum also to GDPR compliance, to data protection compliance inside the organizations. So I'm finding companies which were somehow, they became somehow, I would say, cold about GDPR compliance because too many years were passed. Finding again commitment and interest for this matter, which is good, not only for lawyers. And I will. It's not just a matter of work for consultants, for lawyers. No, it's good for compliance in the sense of protection and safeguard of fundamental rights of data subjects, of users. It's good for the ethics also, and the ethical posture, I would say, of organizations. So this is something very good that I see, and it is directly linked to the certification effect, to the certification process effect, revitalizing the interest for this matter. That's it. I would like to talk for hours about my experience as implementer of the Euro Privacy certification, but I will give the floor to Giovanni Francescutti and again to you, Sebastian. But I hope I was clear enough in communicating the main aspects that as a lawyer, a data lawyer and implementer, I can witness helping companies in the journey of certification. Thank you.
Thank you, Luca. And I think, Giovanni, if you want to take the token and your perspective as you are really directly interacting with companies, small, large companies, embracing certification. So the floor is yours, Giovanni.
Thank you, Sebastian. Well, first of all, I must admit that I'm a little bit uncomfortable because I probably am the only engineer in a room of lawyers. And I'm aware that everything that I can say or I'm saying could be used against me. But, you know, jokes apart, I am an engineer. I'm working for a certification body. So at the end, as Luca and Sebastian were presenting before, we are the company that are verifying the compliance and issuing, you know, the market statement that declares that the company is compliant towards the Euro Privacy scheme. We are discussing about this, but could be for other schemes. The certification body is a company, it's a particular kind of company. You know, we are a multinational company. We are very big. We are a global company based in Norway, but working all around the world, mainly in Europe. You know, we're working in all the geographies. We are doing certification. Certification is, as was said by Luca, is what we do. We are verifying against some requirements. That could be a checklist of requirements that the company, the product, wherever we are verifying is compliant with these requirements. If the product, the process, the company is compliant with this requirement, we are issuing a statement that is a certificate called that is declaring that this company is compliant with these requirements. To give you some example, could be that we are certifying a ship, we are certifying cars, we can certify trains, we can certify the environmental processes of companies. And in this moment, we are discussing about the possibility to certify also data processing activity under the hat of the GDPR, like the case of Euro Privacy. The scheme, what we do is going into the company, interviewing people, verifying how the processes are managed, and we are compiling and checking that all the points of a scheme, that could be the GDPR or Euro privacy, that is collecting all the points of the GDPR, and as Luca was saying, transforming these GDPR points in a verifiable list of questions at the end, because it's a checklist. We are entering into the company, staying there for 5, 10, 20 days, depending on the dimension, the complexity of the company, verifying all these points and verifying if there are some deviation from these requirements. We agree with the company eventually if there are some deviations on how to handle this. You cannot give consultancy. We are an independent third party. You are not building the process for the company. You're only assessing and verifying the processes. And once all these points are closed and the gaps are covered, we can issue the certificate that is the market statement of what the company could do. So our job is measuring compliance at the end, based on the list of requirements that could be available on the market, and Euro privacy is one of these requirements. The statement that we are issuing are having a validity. For the GDPR, for Article 42, because we are accredited, have a validity that is covering and demonstrating that there is a real compliance, that also for the company could be really sold on the market as an added value, both for processors and controllers, because it's demonstrating that the company is doing its best to fulfill of the requirements of the scheme, and is giving security and awareness, as Luca was saying, also to data subjects and controllers, eventually if you are a processor, that you're doing the best job possible to defend this data, to protect this data. I think that an important point, and then, I leave also, I do not want to spend too much time, describing what we do, because then as Luca was saying, we can spend hours telling you exactly what we do, the interviews that we did, how we are doing these interviews, what are the issues that we have. But because, you all are interested in understanding also what could be also in a professional development, the job of a verifier, we as a certification body we are a company of engineers. Just to clarify, DNV is a company of 15,000 engineers doing technical jobs around the world, verifying a lot of things. And up until 5-6 years ago, the logic of this certification body, so also DNV, where I'm working since 23 years, was mainly doing technical assessment, cybersecurity assessment. In this moment, it's changing a lot, this logic. The Euro privacy scheme, just to clarify, is a mix of requirements that are technical requirements. One of the points is that with the GDPR, you are assessing also the adequacy of the security measures that a company is putting in place. And if you consider this is very technical, you go in the company, you talk with the IT guys, you understand exactly how they are defending logically and physically also the premises of the company to be sure that the data are not accessible. You audit the business processes of a company, so to understand which are the responsibility given in terms of management of data inside the company. These are very technical things that even an engineer could assess. But then, when you have schemes like Euro privacy, you have requirements that are more legal. If you have international companies, you have also situations where these legal requirements are a mix of inputs coming from different legislation that you need to assess correctly to be sure that the company is doing the right thing. The engineer is not enough. In this moment, we as a certification bodies are all the certification body, but we that are working mainly in this kind of like schemes like Euro privacy, we are actively searching also for auditors that are legal auditors, people that are able to read in different languages, in different legislation, the complexity of what the company is building. Because at the end, when the audit, like Euro privacy is done, there is a mix of half technical matters and half legal matters that need to be assessed, verified, and only if there are no deviation or the deviation are covered by the company, we can be sure to issue the certificate. So this is an input also for all of you to open also the idea that the world of the certification is a world that is becoming more and more complex, is becoming more and more interesting by my point of view, and where Euro privacy is one of, I must admit, also the first schemes where we are mixing so much the logic of legal and technical requirements. And this is interesting also because it's becoming a very interesting also discussion between companies and auditors. And the certification that in this moment, the certifications that in this moment we are issuing, collaborating between the scheme owner, us, and the data protection authorities and the accreditation bodies, are, by our point of view, as a certification body, very interesting also because are opening a future of compliance and way of demonstrating compliance completely new, compared to the one that we are used to have years ago that was mainly technical. Sebastian, I think I told everything. So up for questions.
Thank you very much, Giovanni. So we still have some time for some Q&A, which is great. What I will do, I will just share one or two information and then open for the Q&A, so I can remove, or maybe no, wait, let's take the Q&A now. Let's do that, but I will need the support probably of my colleagues to access. Let me see, to be able to see the Q&A.
Someone is writing.
And as you mentioned, Giovanni, that's something I can confirm. We see really a paradigm shift. Again, we see the world of legal expertise and certification with very strong expertise on both sides, but looking very closely indeed with very different framework reference models. And these two worlds are coming together. And that's very interesting because it means that for lawyers, for junior in particular, there is a quite new career opening to them, which enables to combine the legal expertise with this quite unique profession of auditor, in particular freelance auditor, who are meeting all kinds of clients, interacting with many different stakeholders, who will rely a lot on their intellectual skills to be able to assess, to document, to demonstrate compliance. And I have to say it's intellectually very stimulating, including for people who are very much focused on legal aspects. That's opening a quite new world, a new dimension.
Yes, also because, it's interesting because, for example, doing an audit is not a difficult job. Is verifying that there are not contradicting parts of the company. So, for example, you can have a legal part of a declaration or a request for consent that is declaring something, like, for example, you retain the data for 10 years, but just as an example. But then you need to mix this with the fact that you need to audit whether it's true that they are retaining the data for 10 years. That is very technical. And it's a lot of job, also the audit work that we are doing, mixing, the competence of the engineer, the cybersecurity engineer, of the, the engineer on informatic matters, together with the lawyer competence to understand also, to balance also what we are doing as an audit, to understand exactly what the company is doing. And also, because our scope is not blocking the company, it's working, understanding and making evident to the company if there are some things that need to be solved, to be sure that there is also not a conflict between how the company is working and how the legal part of the company is declaring, or working. It's a very interesting job, but it's a future, probably by my view, is a job for the future that is going to become very, very interesting.
Absolutely. And that's quite aligned with the first question I see. What practical steps would you recommend for law students who want to specialize in data protection and privacy law? So maybe I will give the floor first to our colleagues, Luca and Giovanni, and maybe I will complement after with maybe a few words on the academy. But Luca, what would you recommend? Because again, and that's something, if I may just make a preliminary remark, there is something quite interesting that I discovered personally working in this environment. You meet incredibly smart and brilliant people. It's a domain where you find a lot of intellectual brightness, and you in particular meet people who have been active in this field before the GDPR and who have a quite deeper perspective on privacy. And Luca is one of these experts who have started to work on privacy quite before the GDPR. So Luca, maybe you can have a good insight and suggestions. And what would be an advice to a junior lawyer who would like to to engage in this field?
I would strongly suggest to do a master's degree, an LLM, focusing on data law, on TMP, and possibly an international LLM dedicated to these topics. This is the first suggestion. I see ourselves, but also other firms, this element is very valued and taken into account. Then, of course, the second suggestion is to start practicing in a firm that is specialized enough in these fields, and of course the reasoning on the new brand new profession of auditor, of GDPR certification auditor you mentioned is absolutely right, and I would say I would add another good reason to consider the auditor's job. This is a job that will be able to resist and to be resilient, also to the possible risk of replacement implied by AI. We all in the law firms, we all discuss since years about the possible effects of AI on our profession. And there are some jobs, some activities, some practices that will continue to valorize the human factor. And the auditors, the GDPR certification auditors, have to be humans and will be humans, and that is not trivial.
Thank you very much, Luca. Let's move maybe another element just on this question for practical steps. As Luca mentioned, to practice, to engage, LLM can be a master degree can be good. Then you have internship. As we mentioned before, we have a close collaboration with ELSA to welcome interns to join us to do research on data regulation compliance, data regulatory compliance, quite a number of ongoing projects with the European Commission, so European research projects, also internationally. But also you have the possibility to go and to take advantage of the Europacy Academy. And there again, we have a special agreement with ELSA. We have quite a number of free registration provided every year. And we have also for very affordable options for any ELSA students to join the Academy. So you are welcome to dive into this world. And I'm sure you will enjoy it. You will meet fascinating persons and experts, and it's a great experience. Now, let's move to the next question. What are the most, maybe I will quote it literally, but I will rephrase it. What are the most popular reasons for refusing to issue a certification to a company? Maybe I will replace popular by frequent. I'm not sure if there are popular reasons to refuse, but maybe, perhaps. Giovanni, what would you say?
I can take the two questions. So the first one, what is the more popular reason? Look, usually the first reason is that the data protection officer is not independent. So one of the main reasons is that you see that the data protection officer has a role in the company that is not giving the correct independency of the role to the company. This is one of the first. The second one is mainly, look, the example that I was telling before, the company declares that is retaining the data for 10 years, then you go into the data, sampling the data, you find data older than 20 years. So these are, the most, normal issues that you see. But the first one of the data protection office is one of the blockers that usually we have into the certification process. I must admit that the company, when are asking for certification, are arriving well prepared. So it's not so frequent. The second point that is if a company that is certified is not complying with the GDPR, I assume it stopped to be certified. Would it be possible to be acquired the certification after? And would the process to reacquire the certification be harder? Look, everything is ruled. So in this moment, the accreditation is telling you what to do. If you give to the customer a certificate, means that the customer is compliant with the requirements of the scheme. Then could be that they are going to have an incident or something that is not could happen. So in this moment, it's not that the certificate is automatically withdrawn and retired. The certificate usually is suspended for a maximum period of 6 months, where the company has time to put in action a corrective action to solve the problem. If the problem is solved, the suspension is retired, so the certificate is becoming active and valid again. If after 6 months this suspension is not, the company is not able to put in place a solid corrective action that the certification body must verify, then you have the withdrawal of the certificate, meaning that you retire the certificate stops to have its validity. Everything is well ruled. You have 2 or 3 levels also of appeal that the company could have. So there are some points that could be applied. After that, the company could reapply for another certification, but the path for the new certification is similar than the initial one. So we try to start always with a clear, mindset. For this Euro Privacy certification and all the data protection seal, you need always to be aware that in this case, it's not only the certification body that could ask for a suspension or a withdrawal certificate, but it's also the data protection authority. So in this case, the scheme has a little bit of a complication where could be that the data protection authority, for several reasons, could ask the certification body to suspend or withdraw or retire the certificate, and this is something that we can accept because is how this data protection seal is, required and defined into the Article 43 of the GDPR. But for the rest, I think I told you exactly how the process works.
Thank you very much, Giovanni. I think we are close to the end. What I would like to do, as I see no other question, is just to share 2 information very briefly that can be of interest. Let me share again my screen, and then we can have a closing words of conclusion for everyone. If time allows, I let my colleagues from ELSA let us know if that's fine. So first of all, there is a white paper which is available online in different languages. You just need to scan the QR code or to go on the EuroPIC website. You can find it. And that gives you a good overview of the EuroPIC certification, the requirements, the value proposition, and so on. So you are very welcome to download it. Then another opportunity for you, for those who are interested. As you know, we are so collaborating with ELSA in this context, but we have the European Center for Certification on Privacy, together with the Council of Europe, with several regional DPO associations and so on, organize, and the Italian Institute for Privacy, organize a privacy symposium conference in Venice every year, since now for about 4 or 5 years. This conference brings together, if I may say, the cream of the cream in the field of data regulation and data compliance. So we have a lot of heads of authorities from Europe, European commissioners, ministers of justice from several countries coming to Venice to join the conversation. It's a period where it's a conference where we really encourage and we focus on supporting international dialogue and cooperation. And we have a dedicated program on data protection certification and accountability, where we'll discuss the role of certification in cross-border data flow, the international recognitions, the convergence among different frameworks in Europe with European regulations and non-European regulations. And there's so a whole program on Wednesday, April 22nd, which will be focused on international accountability and data protection or certification of data processing. That could be of very high interest for those of you who are interested. There are quite a number of deep dive-ins, training courses. You have, again, the highest representative from the industry, from the regulators, not only in Europe, from the US, Japan, Australia, Singapore, Canada, Argentina, Brazil. So very high level participation, a great opportunity if you're interested to dive into this world of data regulations, digital governance, and the opportunity to meet very high-level participants. And for these, there are special conditions and offered. So we have over 300 speakers over the week. You can see some of them here. You may recognize some faces, but for those of you who would be interested, there is a special voucher for ELSA members that you can use to register to the conference. So feel free to register and to join us. And if you face any difficulty, let us know. And we always try to find solutions. So if you're interested, we welcome younger generation to engage at international level. We will also be discussing qualification of DPOs and compliance officers. So there may be several sessions that could be of very high interest to you. And in terms of networking, it's a quite unique opportunity. So I will stop here. I want to thank you all, and I will give the floor. So maybe just to give a last round of closing remarks from our colleagues, and then to thank our colleagues from ELSA for co-organizing this webinar. But maybe, if, I don't know if Luca, Giovanni, you want to share a last words of conclusion or idea or message you would like to share?
We are actively searching for auditors. We as DMV, we are actively searching for auditors. So for us, it's only to push also to think about also the new profession that these kind of activities are going to open for everyone.
And I can say that we are actively searching for implementers. So from our
So shall I continue the harmony that we are all welcoming new talents? Again, we can promise you that it's a new career. I know that there are questions sometimes. You study law. I remember a survey from ELSA where they realized that 50% of students in law didn't want to be lawyers. They wanted to explore something new, different. And I have to say that's probably the area where you can combine your expertise, legal expertise, and developing many other skills like human relationship, intellectual challenges, innovation, new technologies. And for sure, as Luca mentioned, AI and legal tech will disrupt the traditional profession in the legal field. But for sure, what we are doing and this evolution of reinforcing, developing new approaches to assess regulatory compliance, to address new regulations, to address digital transformation, is just the beginning of a long journey. So if you are interested, feel free to contact us, to check with ELSA colleagues how to outreach and to come to us. But there is a beautiful venue for those who are interested by challenging and interesting and stimulating careers. It's really an area where you will not be bored. You have a lot, and a lot of innovations coming and new challenges. So very welcome. And I don't know if our colleagues from ELSA, if you want to say, Miguel, if you have any comment.
Just a final remark. First of all, thank you all, to you three, to our speakers, for your presentation. It was very insightful. And yes, thank you a lot for everyone that joined today. We'll have another session tomorrow at 4. So we will see you tomorrow at 4. And since there are no many questions, I think we can end for today, and we'll be back tomorrow.
Thank you very much. And thanks to our co-panelists. It was a great pleasure to have this session with you.
Thank you. Thank you, everyone.
Thank you.